cannot die before parents, that it is not the normal and proper cycle of life and death. But parents do lose children, tragically to illness, to accident, to negligence, even murder. Murder by a stranger is a horror, but deliberate murder by friends is unthinkable. It must be unbearable for Dave and Mary Neese to contemplate the fact that Skylar's friends hated her so much that they took her in the dark of night and stabbed her to death even as she struggled for life. They were single-minded and relentless. When we go through troubled times, we may wake up on a morning that seems new and trouble-free for the few moments until the trouble comes back to our minds. I imagine that Dave and Mary Neese wake up some mornings and that there are an easy few minutes until the fact of Skylar's murder comes rushing back, and the unbearable must be borne again and again for the rest of their lives. Surely, no lesser sentence than those years of imprisonment available for second-degree murder is sufficient for justice here today. Surely, for this oh-so-adult crime of cold-blooded, planned, premeditated murder, there is no proper sentence other than an adult sentence. Surely, a sentence as a juvenile is unthinkable. If Rachel Shoaf has accepted full responsibility for her crime, she should not be asking to be sentenced as a juvenile. She should be willing to accept every day, every hour, and every minute of a proper adult sentence. Your Honor, you know this case. You know what a proper sentence would be. We ask that you impose that adult sentence.
Rachel Shoaf, for your conviction of the offense of murder in the second degree, the felony charged in the prosecutor's information in this case, it is a sentence of the court that you be imprisoned in the West Virginia State Penitentiary for a period of 30 years. The court assesses court costs as required by law, would order that you pay restitution in the amount of $921.71 to the West Virginia Crime Victims Fund, and in the amount of $7,262.22 to whoever ultimately assumes responsibility for that obligation, be it either the funeral home or the Crime Victims Fund in West Virginia or Pennsylvania or whoever. You will be jointly and severally liable for that obligation with your co-defendant, Shelia Eddy. Although I don't recall addressing the issue of restitution at her sentencing hearing, so that will need to be addressed either by an agreed order or at a separate hearing, and you can take care of that at any time in the future.
Your Honor, just so you know, I have discussed that with Mr. Benninger, and we will enter an agreed order. We will offer that to the court in conjunction with this hearing.
Very well. Did not expect that it would be an issue. I would further order the defendant and Ms. Shoaf pay a one-time $10 fee to the Montague County Victim Witness Assistance Program consistent with the provisions in the code. The defendant has received the benefit of her bargain, and that was a plea to a lesser offense of murder in the second degree, an agreement by the federal authorities not to prosecute her federally, which, as I understand the law, they have every right to do, even and in spite of the pleas that were entered here, and the agreement of the authorities in the state of Pennsylvania not to prosecute her there, even though, as I understand the law, they have every right to do so. One other issue that I suppose needs to be addressed at this time, since the defendant is still a juvenile, and she will remain in a juvenile facility and a hearing will be scheduled prior to her 18th birthday so that a determination can be made as required by law whether she will remain in a juvenile facility past her 18th birthday or will be transferred to an adult facility.